Welcome everybody to our webinar on legal errors in family law cases. Today we're covering property and money issues. It is May 17, 2024, and I want to introduce our incomparable guest. We have the Honorable Tina Yost Johnson from Calhoun County Circuit Court and Liz Bransdorfer from Mika, Meyers in Grand Rapids. And I want to remind everybody that we had Judge Tina Yost Johnson and Liz Bransdorfer last year, I believe it was last June 2023, to talk about legal errors in family law cases. And we thought we were going to do everything in 1 hour, which is completely unrealistic. And so we just spent all of our time last year on custody and parenting time issues. And we decided that we only got halfway through our list, and they agreed to come back. Thank you very much. So we could talk about the other half of the equation, which are the property and monetary type issues. So welcome everybody. And just by way of introduction, in case you weren't here with us last year, Judge Tina Yost Johnson and Liz are both co-chairs of the Family Law Section's dedicated Family Law Committee or Family Court Committee. And I'm on that committee with them. And we have been working as a committee for multiple years on trying to find a way to bring in judges to the family law bench who are experienced in family law as part of an effort to reduce the number of legal errors we're seeing in family law cases. So they're the perfect people to have with us today. Thank you both for being here.
Thank you, Lisa.
Yep, glad to be here.
So anyway, let's get started. I don't want to spend a lot of time on background information, but we're going to, like I said, focus on legal errors. And part of the reason, the standard of review and how the trial courts and the Court of Appeals handle mistakes by the trial court are different depending on whether it's a legal error, factual error, or if it's a discretionary decision. So legal errors are, I think, what I would call the easiest errors to correct, because the law should be the same, whether you're in Calhoun County or Kent County or Traverse City or Marquette. The law should be applied the same in all around the state. Whereas factual errors are really hard to overturn on appeal, because that has a lot to do with witness testimony and credibility issues, which we give a lot of deference to our fact finders. And then discretionary issues, we're not going to be covering either of those today either, but discretionary issues, you have to have an abuse of discretion in order to reverse a trial court, because the judges are given a lot of latitude on discretionary issues, such as evidentiary rulings, for example. So focusing back on legal mistakes or legal errors, we're going to be talking about, let's just start with property division cases. And I welcome insights from both Judge Tina and Liz, but we see a lot of, so there's not very many appeals on property division, but when they are appealed, there's a lot of times mistakes being made. Liz, do you want to get started?
Those of you who've been around a while know that I used to do an annual property law update for ICLE. And I went back over some of the materials that I had prepared, and at least 3/4 of the property cases where a lower court was reversed and a case was vacated or remanded were because the trial judge didn't make findings. For the reasons Lisa said, if your judge does make findings and says, here's the facts, I'm doing this because, they're almost always going to get affirmed. The legal error, I guess, is primarily the procedural error of not making those findings in the first place. The law is very clear that if there's a dispute about an asset, the trial judge has to make findings about what that value is and then who should get it. The issue is assets, but that also applies to debts. So you can't only value the positive assets and ignore the negative assets. You have to look at every asset and liability in the marital estate before the judge is entitled to make that discretionary decision about, am I departing from congruence, and am I explaining why I'm doing that?
Now, before I pipe in about what I've seen on appeal with regard to that issue, I wanted to see Judge Tina Yost Johnson, if you have comments or feedback about how you approach property division cases when those do like even though infrequently when they do come before you?
So one of the things I would say is Liz gave a perfect example. We don't see things always being laid out. So for example, the classification of property, is it marital? Is it separate? Sometimes I see parties conceding things and I'm like, why are you conceding this? It doesn't make sense to me. And I'm thinking maybe they shouldn't have conceded it. But since there's no real explanation, it's just laid out. Here's the items. It's tough. The other thing is attorneys will, they'll fill out their property charts and it's like, well, my client thinks it's worth this, which the burden of proof, as we know, is on the party claiming the value. However, sometimes I get very little to support it. Parties don't want to spend money on appraisals. They don't want to do the discovery work. And so as a judge, it can be very difficult to make some of those decisions when we don't have good information to make it with.
So one of the things I've seen on appeal is where a lot of times it comes down to the attorneys not properly presenting the issues and the information to the judges. But a lot of times I see the judges dividing property and they're thinking to themselves, and you can tell either they say it or you can tell from their reasoning that they're intending to do something close to 50-50. Mm-hmm. And then when you put it in a chart, which we've often had to do on appeal for the first time because there wasn't a chart presented to the trial judge, or the trial judge didn't create a chart themselves. But when you chart out the assets and liabilities and show what each party received, it turns out that it's very far from equitable or even close to equal because, for example, the liabilities were only put in one party's column and not split between the two parties. I wanted to point out a very good article. I'll have to go hunt it down, but Mark Bank, I would say I would qualify him as an expert on this area of law as well as, so Liz would be our West Side expert and Mark Bank is probably our East Side expert. He did a really good article about the process of classification and identification of what property is and marital versus separate, and then in going into invasion, and we'll get to that in a minute.
So can I did an article here?
Yeah, go ahead.
Lisa? Mm-hmm. The decision is something marital property or separate property. One of the mistakes that happens there in that initial classification has to do with kind of the confusion between property that becomes marital because it was commingled and property that the judge is looking at invading on the basis of the other spouse's contribution to property that remains separate. So as Judge said, you start by classifying it marital or separate. I mean, then the next step obviously is valuing it, equitable division, and then you look at whether separate property should be invaded. But you need to make that initial classification of marital separate 2 steps before you get to the idea, well, I helped this separate property increase in value, so I should get a contribution credit.
Right. And we talk about parties getting advice before they get married, kind of the prenup type thing. I do see some instances where parties either didn't get good advice or they didn't get advice at all, and they think that their property is separate, but they've clearly done things that make it commingled. And so they either haven't sought advice or the advice they got wasn't the greatest in line with the case law to keep that property separate. And they're often pretty shocked. I can think of some cases in particular where I had parents that had children and they intended to retain all their property for their children in the future from a previous relationship. And it's clear that everything got commingled and messed up. And when the divorce happens, that set aside that they had told their children would be there for them for college, etc., is not there. We have to divide it. And no matter how much that pulls on your heartstrings as a judge, because you see these kids now suddenly in a different financial situation than they would have been, The fact is that if it's commingled, it's commingled, and we have to go forward.
So a couple of comments from the chat that I wanted to share with everybody. First of all, Ron Food, thank you for shouting out for Jim Harrington. I actually think of Jim Harrington as being an expert on attorney's fees, but yes, I'm sure he's very well versed in property division issues as well. And then what I was going to say about property division is that the starting point that we always use at our firm is to create a chart. And like I said, a lot of the trial court records often don't include them, and it's really helpful. And even if it does include it in the trial court record, they're maybe double checking the values and whatnot, and making sure that the numbers are coming out accurately. But Susan Denke brought up a really good point, and I want to get a little bit into valuation about the burden of the party claiming the value of the property. But what do you have when you have two parties disagreeing? And Tina Yost Johnson, you mentioned the fact that a lot of times parties are not spending the money to have appraisals and whatnot on different pieces of property, or maybe equipment or cars. What would be your approach, either of you, when the parties don't want to spend the money on appraisals, but they have competing values? What do we do then?
So there's a couple of things. I will say that it has been effective in the past when one side gives a ridiculous value for some property, and I say, well, fine, if you're willing to pay that for it. When you turn the tables, it's not worth that anymore. When they say, the business is worth 500,000, you say, fine, I'll grant it to you and put 500,000 on your side. They want nothing to do with that. So talk to your clients in advance, because it's almost guaranteed they're going to get asked a question like that. And I'll be honest, most of them don't have really great answers when you flip the table. They don't expect you to do that. But judges do, there's clear case law. We have the ability to order appraisals if we think it's really necessary for a case. I have done that. I think that there are cases that I just cannot do this. Of course, that affects our ability to move the cases timely and effectively, because it delays things. But one of the things that I have tried hard to do up front is address scheduling and make property charts due before mediation, so that the mediators have those charts. I don't understand how a mediator can mediate something if they don't know what they're mediating. So one of the ways that I've tried to address that is have property charts due prior to mediation and turned into mediators. That wasn't actually my idea. I borrowed that from someone else, and it came in.
Are you ordering that in your scheduling
I do.
order?
I put it in my case scheduling orders.
Okay.
Yeah. And so my mediators know that they're going to get that property chart up front, and it is helpful. I also, when I'm making my decision, I do use and make my own property charts, or I'll use the parties. One of the things I do to enforce my property charts is to say, if you don't file one, then the court can consider the other party's property chart. So both sides need to list out the property and the values. Now, clearly, if there's disputed, but it just lays the case out early. And I do find that it appears to help the mediators resolve the cases. And when they don't resolve, it helps us narrow down the issues for trial and determine if we need that extra appraisal or if we need something else.
Yeah,
Liz, have you seen other judges ordering property charts? Because that's something I don't, not that I'm looking at a lot of scheduling orders when a case is on appeal, but I don't hear about that happening. So maybe.
Yeah. So a particular format of a chart, some of them not a huge number, but most of them in the schedule or in the settlement conference order require a settlement conference statement that lists the assets and debts and gives values. So some attorneys do that in a narrative form rather than in an Excel spreadsheet form, but you do get that. The other thing I was going to say is if all you require is a list of assets and liabilities with values before trial, you don't know if there is going to be a dispute about value. So you get to trial and you find out there's no real good evidence of value, just the parties' opinions, which is admissible and can be enough, but might result in the delay that you both talked about. I do have recollection of a couple of judges' pretrial orders that also required, if there is a dispute about the value of an asset, you must have a third-party appraisal. I did see one that said, you know, as to personal property, if there's a dispute, you either give me an appraisal or I'm going to order a huge yard sale, which I think would be an abuse of discretion by the court if it went up to the Court of Appeals. I don't think you can make people pay for a personal property appraisal or risk losing, you know, their personal property. Maybe you can, I don't know, because they couldn't afford an appeal. So are they all, or when there's that threat and the judge is actually going to carry through with it, they settle after that, so it doesn't get to the
They're
court
not going to get very much out of a yard sale. It's going to be
No.
fire sale prices.
Yeah, you know, but I'll go to the yard sale at your house and, you know, buy everything. Well, can you go to the other party's yard sale? I don't know. I mean, those are bad. Those are, I think, legal mistakes that judges make, telling people that they have to do something if there is another way that they can present adequate evidence for the judge to make a decision.
Judge Yost Johnson, I'm asking you this more like obviously as a hypothetical, because I don't think this is something that would come up in your courtroom. But what I've seen happen in cases is where maybe the parties haven't presented a value of something, whether it's like a car collection or something like that. And then the judge awards it to one party or the other, but it has no value like associated with it. You still have to like count it as part of your award, like unless you somehow divide it equally. What would you do like if the parties came to you without having put a number on it? I'm at a loss when it's something major. Like I'm not talking about the China set or the lawnmower. I'm like, I've had cases where it's literally 10 vehicles, or one time it was a business was an automobile sale, the automobile dealership, and the inventory was not included. There wasn't a value put on the inventory, which is an asset of the business.
So again, there's a couple ways you can do it. I've often found taking the testimony of the part, I mean, some people are very knowledgeable if they're collectors, right? They can testify to values and how they base their values and how they got their values and what they paid for the vehicles, or if they had an insurance value appraisal. So the first thing I would do is fish out that information, right? Do you have them insured? What is the value they're in? If it's an antique collection, a lot of people will have them insured and they'll have an insured value on it, right? So you can ask those types of questions of the parties and try to get the information. If there is absolutely zero information, as I said, I think the court has the authority to require the parties to get a valuation. And then you can make the determination, you know, we're going to get into attorney fees and costs and things like that, but you can make the determination of who pays for it based upon need or ability to pay. One of the things I'll have one party say, well, it's worth zero, and the other party say it's worth an exorbitant amount. You know, they'll say, oh, they have this antique collection, and the one person will say it's junk, it's not worth anything, it's old garbage. And the other person acts like it's worth $500,000. The first question I have there is, well, if you think it can be sold for that, should we award it to you so you have the ability to sell it? Most people back off that very quickly. Sometimes you can see that people are putting sentimental value in exchange for financial value, and you have to weigh that out. But again, I think that every case is a case-by-case basis, but we absolutely have the ability when there is just zero and nothing to go on. You can take testimony from the parties and weigh credibility, or you can order an evaluation if you think it's really necessary.
So we have some good comments coming in from the chat, and then we'll switch to another topic. So first, Susan mentioned that in Jackson County, the judges are requiring charts, but there's no consequence if the parties don't do them. I'm thinking if one party does it and the other does not, then the easy solution is just pick the party's value who provides you the evidence, right? What else are you going to do? And I think, Judge, you've already addressed like what you do in the absence of having that information provided to you. And then another good question from Serafina is about is it permissible to require for the judge to require the submission to the court of values for mediation when mediation is supposed to be confidential settlement?
And again, I'm not requesting it for the purposes of mediation. I require it to be provided to the mediator, but I require them to file a list of what's the contested property. And I think I absolutely can require, list out what you're disputing about, right? That's what I want. And then, you know, what are your issues? If the parties agree on the value, there's no dispute. So I do think we're able to do that. As far as offers though, you know, I get this, you get that, that's different, right? That's mediation.
So let's switch gears slightly and talk just for a minute about prenuptial and postnuptial agreements. I wanted to see if either of you had any observations about legal errors that were being made in the postnuptial and prenuptial agreement context.
I have not come across anything in a long time that was a problem in the prenup, postnup situation. The reported cases make clear that they are going to be interpreted as contracts. So if you have one and it's been a while since you took your first year contracts class, or you haven't thought about basic contract principles since your first year of law school, it's worth taking a look at some of that. It's important enough that Judge John Van Allsburg and I are speaking on contract principles in family law at the Family Law Institute this November.
Good plug. Thank you.
Those are the fundamentals for determining if a prenup or a postnup is going to work. And I mean, it's offer, acceptance, consideration, lawful purpose, which may or may not still be an issue with regard to postnuptial agreements. And then whether or not it is sufficiently definite to be enforced. And I think that is frequently a problem when the agreements are written by primarily estate planning lawyers who throw in some language that would apply in the event of a divorce without really thinking about how does this apply in the event of a divorce.
Judge Yost Johnson, do you see many of these issues? I would think not, but
I don't. As I said, the things that I see are people that either fail to get advice and think that they're doing the right thing, don't follow the attorney's advice, think that they're separating assets when they're not, you know, pay for things out of marital funds towards assets that they think that they've somehow kept separate. So those are the things that I mainly see. Or just the only other thing I can say is the timing of the documents, which we all know that's been an issue. That's not a new issue. But you know, making sure that there's time to review it and that it's not a last minute thing or something that they feel that they can bring up the issue, because even if it does hold up, as we know, the cost to litigate an issue in and of itself can force a settlement that or make a contested issue that wouldn't have been there at all. You wouldn't even have an open door if it wasn't for timing in some of the cases. So just make sure that clients are planning sufficiently in advance. You know, if I see something a week before the wedding, I'm going to look at it harder than if it was signed, you know, months before and they had plenty of time to review it and think about it.
And I'm just going to include, just as a footnote before we move on, the Allard decision that allows judges to invade separate property, even if the prenuptial agreement is enforceable and identify separate property. But in my view, that's more of a factual and discretionary issue based on the language of the statute. So I don't think we need to spend a lot of time on that today. Let's switch gears to support issues with child support and spousal support. One of the things I see, maybe this is more the theme that Liz already mentioned today, the failure to make factual findings, right? So one of the things I see with spousal support, for example, is that a judge will award spousal support and maybe consider one or two. There's like common law, there's like 12 different factors from Sparks or whatever the cases are, that many cases that iterate those factors, and a judge may be only considering one or two of them, or maybe not any of them. Let's chat for a little bit about spousal support and the types of legal errors we're seeing in those cases.
So there's enough of those that I think it's just wise if there's not a fine, you just say there was no evidence presented, or there's nothing contested on that. I still go through every single factor, even if there's nothing on it. I mention it so they don't know so they know I didn't forget it, right? Because I think that's just safe with the Court of Appeals. And if your judge doesn't do that, I think it's safe to say, Your Honor, I'd just like to make a record, because as you know, this comes up in the Court of Appeals a lot, and I know you consider this, but I just would like to make a record. And I don't see any harm in doing that to make your, as I would call it, your order, your judgment bulletproof. The thing that I see defaults being granted and orders just being signed sometimes without making any findings. I won't do that. I had a default this morning, and I made them go through every single one of the factors. And pleading is key, because in this case, there was a specific motion for spousal support, and they specifically pled every single factor. The attorney did an excellent job. So then on the default, I can say, yeah, this is deemed admitted. This is deemed admitted. You didn't file an answer because they filed a separate motion. And I think that practitioners would be wise to do that, because sometimes I see we want spousal support, and then you get a judgment of divorce and an order for $2,000 a month spousal support, and there's nothing to support it, and they want to do a pro con and leave, and that just can't happen.
Liz, we were going to also talk about the default procedures, but let's, before we head that direction, let's talk a little bit more about spousal support mistakes that are happening from your view. And I think you've done I thought you did some articles on that issue as well, or presentations.
I've done quite a bit of work on spousal support, as much on the modifications as on spousal support at the original time of the divorce. People are more likely to agree on spousal support at the time of the divorce to get it over with and to move on, and believing that, they'll come back later and get this taken care of. And that coming back later to get it taken care of is harder than it looks. The law with regard to those modifications, though, is exactly the same as the law with regard to the court awarding it in the first place. They have to make findings on every single one of the factors. And I agree with Liisa, the judge, saying the parties didn't present any evidence on this, so I find that it is not important to either one of them. And so, it's not being weighed in favor of or against either party.
So I wanted to interrupt you for a second, though, because I think the Court of Appeals has said that it's not error to not make a finding on every single factor, like you would have to, like in a best interest, because it's under the Child Custody Act. But I think, to your point, and to Judge Yost Johnson's point, you're going to avoid an error if you've made a finding, even if the finding is this really doesn't apply here, right?
Yeah, I absolutely agree with you. I don't remember reading anything that said it's okay that the judge jumped out, ignored these factors, except maybe in a harmless error analysis. I don't remember reading anything that said that it wasn't error. I do think the judge should mention every factor. First of all, if it's in an original divorce, the factors overlap with the property factors. So you might as well just, say all of the factors relevant to spousal support have the same findings as the property factors, maybe plus this, because the health of the parties isn't going to be as big a deal. Or if you're doing rehabilitative spousal support, the need is only going to happen for a period of time. I have an expectation that somebody's going to become closer to self-sufficient after some period of time. But I just think it is always better to do it right than to do it over.
And it's much more efficient too.
Yeah.
So one of the things
we want Liisa to go out of business, we don't.
Well, I'm trying really hard with dedicated family legislation. Okay, so regarding putting the number on spouse support, which I think is maybe a lot more difficult than in the child support context, which we haven't talked about yet. Any thoughts about how to help the judge calculate or, we see judges putting numbers and we're like, where did that number come from? What can we do to help the judges put better numbers on it? Maybe numbers that aren't going to be easily reversed.
Well, so my perspective is, spouse A makes this amount, their need is this lesser amount. Spouse B has this smaller amount of income and their need is bigger than. So there is this amount of money that spouse 1 has extra, and it's enough or it's not enough to meet the need of spouse 2. And do I want to incentivize spouse 2 to get a job? So you're going to take that into account. Am I saying spouse 2 is never going to be able to get a job? So they should not have to suffer more than spouse 1. Do I think spouse 1 is artificially reducing their income? I mean, or am I awarding a house to somebody with no mortgage so they have a lower need than they claimed? I mean, just say why you're doing what you're doing.
Make findings.
And do it with numbers, just like you do the property division with numbers. And if you've got there's this amount of money to go around and this person should have 35% and this person should have 65% because this person's working and the other one could, or because it's a shorter marriage, so it's not up to a 50-50. I mean, just say why you're doing what you're doing. The Court of Appeals almost never reverses if you articulate a rational reason for what you're doing.
So I would say as a judge, I follow what Liz said and try to put those pieces together, but it's difficult. It would be so much easier if we just had something like we do for child support, right? You shove it in the computer program, it pops you out a number. It would be so much easier, but we don't. And so a lot of times, really advocating for the factors and why we should consider something and how much weight we should give to things, it does make a huge difference in that, because I'll tell you, I've had some cases where I have a modification and I went back and reviewed things and I can't figure out where the number came from. So if I can't figure out where it came from in the first place and there's no written opinion on that, it can become problematic later. So that's the other thing I would say is try to get a good record of where that comes from. Because if we're looking at modifications later, that can be really tough on the judge that gets the file down the road.
Yeah,
which could be a different judge as well.
If the case was resolved through a collaborative process and it's not in your written documents at the end, what's the basis of your spousal support award? The confidentiality of collaborative prohibits you from introducing evidence that says we got this number by looking at this.
Yeah.
Because that you can't go back and say, I compromised this to get that. That violates the confidentiality of collaborative. So those of you who do collaborative settlements, make sure you put maybe more in a writing that would then be available if you're agreeing to a modifiable support amount.
So one of the most glaring legal errors I see in the context of spousal support, although I'm seeing it less frequently now, is when a judge awards non-modifiable support.
Yeah, they can.
And I think now that we've had so many years of staple be staple being the law, I don't see that coming up as much. But I just wanted to point that out, that it's like, if you have a case where the judge says the support is non-modifiable, parties can agree to it if they follow certain, the structure of staple be staple. Judges are not allowed to make it non-modifiable. I don't know if either of you have encountered that in the past, 5 or 10 years.
So I want to bring something up because I think I'm an outlier on this. But I'm solid on it. And because I believe so much in staple and the non-modifiable, if you look at the standard judgment of divorce form, the SCAO form that they fill in, the default, there is no, it says and is forever barred. Spousal support is not granted and is forever barred. If it's a default, I draw a line through that. I don't think I can forever bar spousal support because that's equivalent to non-modifiable. I also had a default this morning on the issue of spousal support. An attorney did try to slip in that it would be non-modifiable. And And I deny that because I do not believe on a default. That's the same as a judge ordering it, in my opinion. So I have a problem with that form, the way it's written, because there is not an option just to say spousal support is not ordered and check the box. It literally says and is forever barred. So I draw a line through it and initial it every time. But I just think that's interesting. If you have a judgment like that you've received, your client comes in and says, look, it says forever barred, but I have circumstances I think I should have gotten it. I think you can bust that judgment open and file.
Yeah, I have judges who say spousal support $500 a month for 2 years, period. And you come back toward the end of that time and they're like, well, no, you can't get more. I'm like, oh, yes, you can.
Yeah, the case law is
So
pretty clear on that now.
Forever barred language just doesn't mean anything.
Sorry, good comments. Okay, we keep on mentioning default rules, and I think we should spend a little bit more time on them because it is like, family law has special default rules, and they came about, I don't know, 10 years ago now. But there's, unlike civil cases where there's a default judgment and the work is done, in the family law context, there's still a lot more work for the judge to do. And I think one legal error that comes up is when judges don't realize that they have more work to do, even though a default has been entered. So I know Judge Tina Yost Johnson, you've made a couple comments already. I wanted to see maybe we can get Liz to weigh in on the default procedures and mistakes we're seeing being made with regard to property division, money type issues with defaults.
Sure. The court rule, just as a quick refresher, the court rule allows for entry of a default. And then it also says that the court may allow the defaulted party to participate. Basically, the court rule is unfettered discretion of that participation by the defaulted party. And of course, the court rule also says before you can have a hearing to enter the default judgment, the defaulted party gets 2 weeks notice with a copy of the judgment that they're asking to enter. So a lot of times judges or in Kent County's case, referees who are doing the pro confesso hearings don't always double check and make sure that there was actual service of a copy of the judgment more than 2 weeks in advance of the default hearing. So, and if you did do that and your counsel there, you need to make a record, Your Honor, just for the record, let me show that this was served on so-and-so, and he's not here or she's not here. If it happens, honestly, it came back in the mail and we don't have a better address. I think you're better off just being upfront with the court about that and letting them know. But if you then are in a default situation, there are some judges who think it's enough if you just ask your client, you've read the judgment, it contains a division of your marital assets and debts. Is that a fair and equitable division of all of your marital assets and debts? And the person says yes. And if the other person isn't there to say no, they think that's enough. Fair and equitable is the bottom line, and they think that's enough. And when they've got a whole courtroom full of people doing their pro-cons, they don't want to go any farther than that. And because of the teeny tiny number of cases that get appealed, I think convincing them that they have to go through and say, I don't know that you have to make value findings about everything, but maybe you do. But I don't think so. And I don't think you have to have, here's a balance sheet, a marital balance sheet, Your Honor. And here's my client testifying this marital balance sheet is accurate, so you can see we're only taking half. I mean, that then puts all that stuff in the public record, which you don't really want to have happen.
But doesn't it have to be based on some evidence, not just the party's testimony that, yes, Your Honor, I believe this is fair and equitable?
Same with, we talked about that probably with custody and parenting time. Mm-hmm. Is this parenting time schedule in the best interest of your children? Yes. Okay, then. That's evidence. And if there's no other evidence, is the Court of Appeals really going to reverse if the other parent was served on time or the other spouse was served on time, had a copy of the judgment, didn't choose to object, and now they're coming in later to do that.
So I would have thought that according to the default rules, that the judge would have to go through and make findings, for example, on spousal support, based on whatever evidence is before it, not just to say this is the amount and this is fair, but make the actual findings just like you would in a trial, but obviously without as much information.
But if you have a child support order, I don't know. It never happens in my experience. It never happens. And the amount of time that would, and think of the poor judges and all those self-represented litigants. Do you really do that, Judge Yost Johnson?
So it depends. And that's where I was going to hop in. So the key issues, I look at large property. I don't think I have to go through the toaster value and those types of things. So if I say, your personal, when I say is your real and personal property divided fairly, I'm generally talking about personal property, right? To start with. And then I look, do you have houses? Do you have cars? Is there anything listed? Frankly, a lot of the pro-pers, whether it's true or not, they check the box that says there's no property to be divided, that there's no vehicles. They go through and check that. And, if they say there's none, there's no need to inquire, right? Now when I first started out, I had counsel that wasn't very happy with me because I received a judgment of divorce and it said, it's a default, and it says house is completely awarded to one side. One side got all the cars, one side, it looked just really lopsided, right? And so I said, I'm going to set a hearing on this. And I thought they were going to pass out because it was a default. But I did set a hearing, and it turned out that I didn't understand the way the judgment was presented, but it turned out that it was a premarital house that was listed. And so that was the type of thing that it really was fair and equitable. But I think I had to make those findings. The things that I usually, I don't, we talked about this, but I know there are courts that take defaults on best interests. I don't think you can award custody and parenting time without findings. I think we're all on the same page on that. You have to go through the factors, right? Same thing with spousal support. I'm not signing a default order on spousal support without going through the factors. I think you have to. It depends on how things are pled, because excuse me, if they've pled enough sufficient to allow you to make those findings, great. If not, you're going to have to set an evidentiary hearing. And do I? Yeah, I do. Do I like to? No, because you're right. We're pushing. Sometimes I think last Friday I had 28 hearings on my docket to get through divorces, all at once. This is a rocket docket. We're doing them fast. And that's a lot, right? Now, most of those, a simple pro-con can go quick. If it's a consent, no problem. But you're right, if there's a few of those other issues. So I'm looking for houses, I'm looking for cars, and so I'll ask them, is this divided fairly? Why is it one side or the other? If it looks relatively equal and they tell me it's relatively equal and it's a default and the other party hasn't shown up, then I'm probably going to go with it. I start most of my defaults with just inquiring on the other side. Is there any reason I shouldn't decide? Have you read the judgment of divorce? Yes. Do you understand it? Yes. Is there any reason I shouldn't sign this? No. That makes it a lot easier, I think, because I inquire on the other side right up front, and they said they don't have any problem. They want me to enter it. So if they tell me they want me to enter it, then I think it's fair. Shout out to Liz Sadowski. She asked, in a default, if a judgment says, does it have to say neither party is entitled to spousal support, or must it say spousal support is preserved? I think you can say neither party is entitled to spousal support, again, as long as it's non-modifiable. The key is that you can't say it's non-modifiable. You have to leave. I explain it to my pro-pers. You either agree to shut the door or it's left open and someone can walk through it in the future. That's how I describe it.
So Liz and I had a case together where the judge had a lot of questions about how to handle the hearing that happens after the default, right? When a default's entered, but there was going to be a hearing to determine make factual findings. And what some of the questions were: can the defaulted party put on evidence? Can the defaulted party cross-examine witnesses? And I don't remember what the ultimate decision was, but I think that the court rule maybe doesn't answer all those questions. And so there's some
So what I
vagary
would say
left.
is, we're a court of equity. We have to make an equitable decision. So I'm allowed to allow whatever in I need to get to an equitable decision. I will say though, if there is a specific complaint and you failed to answer it, and generally I'll give you a one-time adjournment to seek legal advice to fix anything you need to fix or file your motions. You don't do that, and it's pled specifically, I'm going right down that pleading and saying, okay, you didn't file an answer. It says you made, $5,000 a month. You make $5,000 a month. If you don't like it, you're going to have to file a motion later, but you had, not only were you defaulted, but you had an opportunity for an adjournment to seek advice or, come back, and you didn't do anything. So now we're going to go forward. And so specific pleading, I think, is different. If there's, if it's just kind of this open information about, hey, I want spousal support, and there's no specific pleadings as to the factors, then you've got to hold a hearing. And I think, at that point it's open because there wasn't a specific default on that issue. I take a default as you didn't answer what was in the complaint or the motion.
Yeah, so in our particular case, the default was entered 3 weeks before the scheduled trial date for failure of a party to appear at a settlement conference. When counsel was there and told the court they were prepared for trial, and the judge entered a default and then did not allow any participation, he just signed the other party's consent or default judgment, and the Court of Appeals affirmed. And I was very surprised. There had been 0 evidentiary hearings in that case. And there was, there was lots of potential evidence in the record. I mean, both parties had filed settlement conference statements that were essentially offers of proof, and, didn't matter. And that I found disturbing. Then I had another case where the party defaulted by failure to file an answer, and the trial judge allowed full participation on the custody and parenting time. And as to the property, sent us to mediation. We tried to settle it. We did settle a lot. But as to the rest, he said, I'm going to take evidence in support of the default judgment, and I'm going to allow counsel to argue why what she's asking for is not lawful, is not consistent with the law of the state of Michigan. And if you convince me that what she's asking for isn't basically within the range of reasonable, supported by the law, then I will consider opening this up and not entering the judgment. And I thought that was an exceptionally good way to handle it. I mean, to recognize that kids are that much more important than stuff, and to give the one party the benefit of the default and not let the other party completely off the hook for sitting on his hands for 8 months before deciding to get involved.
Yeah, Liz, and I agree with that. I would, the example I gave earlier was only property issues. That was like a DO divorce. If we're talking about children involved, again, I don't know the purpose really of filing a default in like a custody case, because you have to take proofs on the best interest factors and the parenting time factors. I don't,
Except
I mean,
this
I'm still
case
going to let both sides do their job.
The case that Lisa and I were involved with had a custody and parenting time set of provisions too, and the same thing happened.
But there was a reversal for some part of it. We won't get into that, but there was not the whole, Anyway, I wanted to touch briefly on child support. And I think this goes back to our theme of the day, that the problems I'm seeing in child support cases are when like there's a deviation that's there without findings, or, the child support formula is binding. It's not suggestion. So anything else that either one of you have to add about child support issues that you're seeing legal errors on?
just that I've said for a long time, I think my local council has figured this out, but I think deviation is a big area for potential malpractice. Don't state deviation just to get something through, because as soon as they prove those factors, so for example, let's say you say there's a deviation because the other side is paying the medical expenses, and they're not paying any medical expenses, then the other side can open that whole agreement right back up because the reason for the deviation doesn't actually exist. So if you're going to use a deviation, make sure it's real and articulate what it is, because I really think that you give your clients a false sense, and I'll see, well, we just don't want support. That's not good enough. I mean, if it says they're paying extracurricular expenses and they don't do it, then you get to open child support back up. And so, I do think practitioners should be a little more careful on deviation and making sure that, the reason listed is the real reason. Because I think often they're just in a hurry to settle the case and they don't really articulate that well. They're just trying to get something in that will approve.
Yeah, I mean, my deviation cases tend to be more because there's a huge dispute on incomes, particularly with self-employed people, or potential incomes for people who aren't employed. And the parties are compromising. And neither one of them is willing to say, here's what it would be if you use the guidelines, because we can't agree. And the amount it would cost to litigate the actual amount of support is more than they're fighting over. So they just compromise. And it's sort of too bad that the formula doesn't have a compromise as a deviation factor, but you can, I mean, that's what we would just explain. This is why we're doing it.
So we could spend an entire hour on legal errors with attorney's fees. So we're going to have to skip that topic for today, because I did want to have a few minutes to talk about, we've talked about failure to make factual findings as being a big driver of the legal errors in family law cases. And I wanted to see if either of you wanted to share any other thoughts that you might have as to what's the cause of judges making legal errors. We talked a little bit about maybe the attorney's not presenting things to them in a way that they will understand what's happening. Do you want to, either one of you have any thoughts about other causes of the legal errors that are occurring around the state on property division and monetary type issues?
I think some of them have to do with judges not understanding what I call the Skelly rule about post-marital property not being marital property. I see some mistakes there, which is in my opinion a classification problem, going back to you classify as marital separate or maybe mixed. Is there marital separate and mixed, or is there only marital and separate? That's hard to say. Is mixed that invasion thing? But it shouldn't be, because you only get to that if the marital estate's not sufficient, and there's mixed property in marital estates that are sufficient. I'm thinking that it would be better if the judges who do family law cases had better education on maybe the nuance of classifying property. The other thing that I pull my hair out about is the equitable division factor about contribution to the marital estate. And it seems like every single practitioner I know has represented a party who's the hardworking, diligent saver party, and the other party is the sort of lazy, spend it all, not looking for the future party. And they go down this marital path where one party is saving and the other is spending, and then they split up, and the spendthrift gets half of what the saver has saved. And the judges don't use that factor about contribution to the marital estate. And I'm sure that one comes up with me a lot. I'm sure there are others of those equitable division factors that get ignored, that are just perfunctorily treated, because really the only one that's important is their fault, and if not, we're going to do 50-50. And to me, that's a legal error by not actually thinking about it. I mean, most cases will settle, and maybe more cases will settle if there is more uncertainty about the trial process, because both sides could see they might have something to lose if it went to trial. If one side's offering 50-50 and the other side wants more, only one side has something to lose by going to trial, and that's kind of odd.
Judge Tina Yost Johnson, you were a referee for many years, I think, before getting on the bench. Do you have any thoughts about, in a divorce trial or a post, whatever, there's a lot of issues to cover. It's not, and every single one of those issues that have to be decided have a whole different body of law that requires analysis. Do you think that's part of what drives maybe mistakes being made by some judges?
Oh, absolutely. I mean, when I took the bench, I mean, I had been a referee for almost 12 years prior, and I went in and said, it was just mind blowing, because I would not have been prepared to do the job on day one had I not had that prior referee experience, not at the same level that I was doing it. I mean, we've discussed before, there's almost 40 years of case law in domestic relations cases. And I don't really want to preach to the choir, because I think most of the people on here would know that already. But the fact is that you've got to know your audience, and everybody has those days where something slips, where we normally, it comes right to us. But the more you can lay out things, I'm not saying you have to, do a 101 preliminary, brief on every case, but just laying things out, making sure you're citing court rules, cases, statutes, having them readily available. Even today, when I was reviewing my notes and prepping, I had a case that it would not come to me on attorney fees, of course. But it wouldn't come to me. And I had to, put it in and research it. And I pulled it up out of my legal bank and figured it out. But having those things readily available, it just assists your judge in moving it effectively and getting what you need to get, right? So if you have a judge that's newer or has less experience in the family division, I think it's very important that you lay that information out and be honest with your clients. Yes, I understand it's gonna cost your clients a little bit more money, right? Because you're gonna have to do those things up front, but you're either gonna cost it up front on the front end and educating your judge to do it right, or it's on the back end with appeals, right? So as Liz said earlier, let's do it right the first time. Let's slow down and do it the way it needs to be done. So I think explaining that to clients helps them understand, this is a little bit of a complex issue. Again, I've seen attorneys that do a great job when they ask, for spousal support, or they file their motion. They list the factors right out in the motion and put their version of it under each factor. Those little things make a case move quickly. The judge doesn't have to pull the factors. They're right there in the motion, and they run through them, and the other side files their answer, and it's right there. So just little things like that, I think, can not only move the case faster, but get the right result. And that's, again, educating your judges. And as I advocate that judges should have training, that we should be focused on the family. Sometimes there's rotation of judges, and unfortunately, you've got to educate a new judge all over again. And I think you have to be prepared to do that. If you've went through multiple judges on a case, bring up the old orders. Sometimes you may need to order transcripts and say, Judge, I understand this is the prior judge, but I just wanted to remind you, I'm sure you've reviewed the record, but back in January of 2022, this was the situation, and help them along, point them to where to go to get the information. I had a case that I took on that was like 4 2-inch binders of exhibits, and I mean, years of testimony. I can't tell you how many hours I spent just reviewing that case and what happened in it. And the one thing that really helped was both of the attorneys in that case, they did kind of a summary brief to get me up to speed when I started and took the case over. And I got to hear both sides of perspectives of how the case had went. It was really helpful, and it got us up to speed a lot quicker.
Well, I want to thank Judge Yost Johnson and Liz so much for coming on again today. I think we covered a lot of territory, even though we didn't get to attorney's fees. Thank you for your time today. We are at the top of the hour, so I think we'll close this down, and y'all have a great weekend.
Thank you, Lisa.
Thanks.